Good afternoon, Mr. Bridgewater.
Good afternoon.
The SAP research date,
Uh, J July the 15th.
you. Courtroom 2, are we ready to start?
Yes, Judge, we're ready.
Okay, good afternoon, ladies and gentlemen. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. You have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. If you do not have a private attorney, we're providing you with the assistance of a public defender or a conflict defender this afternoon if you choose to utilize their service. Who do we have first?
Start position 2, Ms. Branch.
Good afternoon, Ms. Branch. You have been charged in case 25 CR 003684J with simple battery family violence. Is there a history? Mr. Howard?
Second, 2020 marijuana obstruction. That's it.
Thank you. Afternoon, Ms. Falk.
Good afternoon, Your Honor. This incident happened on June 30th of 2025 at, let's see, 3767 Hogan Road Southwest. The incident that occurred was an argument between the defendant and her husband, Lennox Branch. They were having a verbal argument about taking their child to their doctor's appointment. They began calling each other names. Mr. Branch stated when he tried to walk away from his wife, she called him another name and then pushed him open-handed in the face near his eye. The Miss Branch, as a result of this, was arrested and charged with simple battery family violence. As you've heard, she does not have any previous history other than that null pros case out of Columbia County, but no violence. We are agreeable to an SOB through pretrial services. No further contact with Lennox Branch. Stay away from 3767 Hogan Road Southwest in Atlanta. 1-day anger awareness. No alcohol, drugs, or weapons, and no firearms. If we have an opportunity to sound for Lennox Branch, we put the no further contact on because we were not able to reach out to Mr. Lennox Branch. So if he does want no further violent contact, either it would have to come from him directly or from the public defender's office if they heard from him. That's all for the state.
The court, now is your opportunity. Does not appear so. Good afternoon, Ms. Tucker.
Good afternoon. I have no objection to the state's recommendation for a signature bond for Ms. Branch. As mentioned, her history stems over 5 years ago to a case that was no prost. She is 31 years of age and she's a mother to 2 children, a stay-at-home mother at that, to a 2-year-old child and a 6-month-old child. So we would be objecting to the stay away from the incident location, which is her residence at 3767 Hogan Road Southwest. It is where she lives and takes care of both of her toddler children or a newborn child as well. When I spoke with her about it, she said that Mr. Branch may be agreeable to leaving the home. I also have not been able to be in contact with him as well, but a stay away from the location would displace both her and her minor children, as she is a stay-at-home mother.
So you've tried to contact Mr. Branch, Ms. Tucker, but just have not been able to?
No, I have not even had the opportunity to contact Mr. Branch.
Okay, do you think that you could do that during this court session possibly and see if you can reach him? Because I understand, I want to get his input on this. It concerns me that he's not here with his wife being in custody. So that's a bit concerning for the court. But if you want to try to reach out to him, if she will, or if you can get the number. Ms. Falk, do you have something for me?
I do, Your Honor. Well, I can send Miss Tucker the phone number that we have. We did call Mr. Branch, left a message, and sent a text message. So the state has made efforts to reach out to Mr. Branch. Mr. Branch, for whatever reason, has not reached back out.
Okay, thank you.
Okay.
So if you'll get that number, Ms. Tucker. So for now, it will be a $2,000 signature bond through pretrial level 1 day anger awareness, no further contact with Mr. Branch. She can go back to the Hogan Road address on one occasion with law enforcement. If Mr. Branch is not there, then she can stay. If he is there, then she's going to have to collect her belongings and find somewhere else to stay in the meantime. But if I'm happy to modify that if we hear from Mr. Branch before the end of the court session. All right,
And
good
Your
luck
Honor,
to you. Yes,
oh,
Ms. Falk.
apologies. Our victim witness advocate is going to try again.
Okay, thank you. Very good. Good luck to you, Ms. Branch.
Next is position 3, Ms. Curtis.
Good afternoon, Ms. Curtis. You have been charged in case 25 CR 003685E with willful obstruction of law enforcement officers. Is there a history, Mr. Howard?
Well, 2018 suspended license, 18 theft by receiving, 2012 obstruction conviction. So,
Thank you. Ms. Falk?
Your Honor, there's some additional history that we found in Odyssey. The defendant has that theft by receiving was actually pled down to a criminal trespass in 2018 under 18 SC 161374. The defendant also was on first offender probation for aggravated assault possession of a firearm under 16 SC 146862. I did not see any kind of sealing order that says her first offender has been completed on that case. She also has a 2017 DUI conviction and a 2021 obstruction of a law enforcement officer conviction. On this case, Your Honor, it happened on June 30th, 2025 at the BP gas station at 3040 Lakewood Avenue Southwest in Atlanta. The officers responded and spoke with Mr. Quantavious Berry, who stated he had picked up his wife, the defendant, to take her to work. She became upset, began yelling at him. He stated he was driving and pulled off the interstate into the parking lot of the BP gas station. He then stated his wife threw his phone out the window of the vehicle, and he went inside the gas station and called police. Officers then tried to talk to the defendant to get her version of the events. She began getting loud with the officers. They told her she was being loud and disorderly, but she continued to do so. At that point, the officer tried to take her into custody. She then began struggling with the officer, preventing him from placing her into custody. They ended up on the ground, and she continued to struggle with him, and then he tased her in order to gain compliance. The recommendation on this case, there's currently a $1,000 surety bond preset by the magistrate court. We are agreeable to reducing that to a signature bond through pretrial services. Stay away from the BP gas station at 3040 Lakewood Avenue Southwest in Atlanta. No further violent contact with Quantavious Berry. 2 days of anger awareness and no alcohol, drugs, or weapons. That's all for the state. We would like to sound for Mr. Quantavious Berry. I do understand that he is not the subject of this offense, but it is the predicate act for which the police had to be called out.
Mr. Berry's on the line and wishes to address the court. Now is your opportunity. Ms. Tucker, any objection to any of the state's requests?
We have no objection to any of the state's recommendations on this matter.
As such, it will be a $2,000 signature bond through pretrial level 2, 2 days anger awareness, no further violent contact with Mr. Berry, stay away from that BP gas station, no drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Curtis.
Thank you.
You're welcome.
Next is position 4, Ms. Gattes.
Your Honor, if I may just ask that we hold Ms. Gaddis and Ms. Ju until the end of the calendar. There's some issues that we would need to go off of the YouTube for.
You get that courtroom too?
Yes, Judge, I got you.
Okay.
I
so-
appreciate it, courtroom two. Thank
Thank you.
you.
Yes, ma'am. We can go to position 13, Ms. Wright.
Good afternoon, Ms. Wright. You have been charged in case 25 CR 003694E with theft by shoplifting. It's my understanding that this is Ms. Wright's first arrest. Yes, Ms. Fall.
Yes,
Yes.
yes, Your Honor. This incident happened, I believe, on June 30th, 2025 at the Target at 1135 Woodstock Road. The defendant entered the store, began taking children's clothing as well as children's toys, paint, boys' underwear, and then walked out of the store past all points of sale. She was then taken into custody by loss prevention, brought in, and charged with theft by shoplifting. The state's recommendation on this case, Your Honor, is a signature bond through pretrial services, level 1. And we are also asking for stay away from the Target that's located at, I just gave the address, at 1135 Woodstock Road in Roswell, Georgia. No alcohol, drugs, or weapons. We're also going to request an anti-theft course as part of the pretrial services bond. I will say she has a $10,000 surety bond through the magistrate court, and the state is agreeing to reduce that to a signature bond through pretrial services. That's all for the state.
Good afternoon, Ms. Armstrong.
Good afternoon, Judge. Thank you. No objection to the state's proposed bond.
As such, it will be a $2,000 signature bond through pretrial level 1, 1 day, or an anti-theft class. Stay away from the Target on Woodstock Road. No drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Wright.
Next is position 1, Mr. Armour.
Good afternoon, Mr. Armour. You have been charged in case 25 CR 003683A with 2 counts of battery family violence and 2 counts of simple battery family violence. Is there a history, Mr. Howard?
Second arrest had a battery, criminal damage to property that was dismissed.
Thank you, Ms. Falk.
And Your Honor, just to give you a bit more information on that previous battery, it was a 22 SC 181987 case. It was battery, criminal damage to property in the 2nd degree, cruelty to children in the 3rd degree. The victim was Alexis Jackson, and it was alleged she had a swollen and bloody lip. That case was subsequently null-prossed. On this incident, it happened June 29th of 2025 at the Motel 6 at 1377 Virginia Avenue in East Point. Officers were dispatched to that location. They observed Miss Nevia Caitlin, who had a visible red knot on the left side of her forehead. They were actually notified of the altercation by a Motel 6 housekeeper. They then spoke to other witnesses. Brandy Wilcoxon, who is the employee, stated she saw Miss Caitlin kicking the door of room 320. The defendant opened the door, pushed her, and then closed the door again. She kicked the door again, at which point the defendant opened the door, pulled her inside, and began striking her. Miss Wilcoxon stated she heard Miss Caitlin screaming for help. Miss Tiffany Randall, a guest in room 334, stated she heard Miss Caitlin yelling, "Stop hitting me," and screaming for help. She also heard loud banging noises as though someone were being thrown inside the room. When they spoke to the defendant, he admitted to the altercation. He claimed that Miss Caitlin was angry at him over talking to another woman and kicked his door. And he stated when opened the door, she attacked him, which is actually contrary to the witness, Miss Brandy Wilcoxon, who saw the defendant actually grab Miss Caitlin and yank her into the room. He then stated he pushed her into a wall and onto the floor. She did have not only that knot on her forehead, but visible scratches on her right arm and her neck behind her ear, which was consistent with the struggle. Based on that, the defendant was placed under arrest. As you've heard, Your Honor, there is a previous cycle that includes domestic violence. That was a family violence battery in that 2022 case against a different victim. For that reason, the state does have some concerns, especially as there are witnesses to this incident who saw what happened and are contradicting the defendant's own statement that he was not the primary aggressor here. We are asking for a $5,000 surety bond, $1,500 per each count of battery, $1,000 per each count of simple battery, no further violent contact with Navia Caitlin, family violence intervention program, no alcohol, drugs, or weapons, and no firearms. We did have a chance to speak with Miss Caitlin. She stated she and the defendant lived together at the incident location and they share a child. She also stated that she never called the police and never wanted him to be arrested, which does concern the state, being that she was in severe distress when the police were called, and she wants to continue contact. We would like to sound from Ms. Caitlin at this time. That's all for the state.
Ms. Caitlin, I see you on the line. If you would like to address the court, now is your opportunity. I need for you to unmute yourself and activate your camera, and I will swear you in.
Your Honor, I also will add that she did state there has been some pushing and shoving between them in the past, and the police were not called in those previous incidents, which also gives the state greater concern for Ms. Caitlin.
Okay, it does not appear that Ms. Caitlin wishes to address the court this afternoon. Ms. Tucker?
Yes, Your Honor. Mr. Byron is 28 years of age. He's an Atlanta native. He's obtained certifications in office administration. He, as it's been mentioned, does share a 1-year-old daughter with Miss Caitlin. Just recently missed her birthday, as it was yesterday, and he was incarcerated. He has stated that he is the primary caretaker for his daughter, and he's concerned as to her whereabouts at this very moment. He doesn't know if Miss Caitlin is caring for her or not. He was able to provide me with a consistent address. However, the incident location is where he's staying at the moment. His apartment complex is under construction, so the complex is paying for the residents to stay at the motel. So that is why they were at that location. However, we are requesting a signature bond for Mr. Byron. As it's been stated, he only has 2 cycles. His last arrest ended in a dismissal of that case. He does not have any failure to appears on his record. So we are requesting a signature bond in this matter. He does maintain his innocence. As has been stated on the arrest affidavit, Miss Caitlin was kicking in his door. She was the primary aggressor. That was also stated by the witnesses. And he also has bruises and gashes on his arm that was not taken into account during this incident. So again, we are requesting a signature bond on his behalf.
Recently occurred that Ms. Caitlin does not wish to address the court, even though no further violent contact has been suggested. I don't believe that there's been a sufficient cooling off period. As such, it will be no further contact at this time. He is to stay away unless he can get another room in that Virginia Avenue hotel, motel. Then he's to stay away from there as well. So for each battery, it's going to be a $2,000 signature bond through pretrial level 1. For each simple battery, $1,000 signature bond through pretrial level 1 makes for a total of a $6,000 signature bond through pretrial level 1. 2 days anger awareness, no further contact with Ms. Caitlin, stay away from wherever she is residing, third-party transfer of any minor children for visitation, no drugs, alcohol, weapons while out on bond. If he needs to go back to that hotel room to retrieve his belongings, I will grant a one-time police escort to retrieve those belongings. Good luck to you, Mr. Armour.
Next is position 5, Mr. Hall.
Good afternoon, Mr. Hall. You have been charged in case 25 CR 003687H with loitering and prowling. Is there a history, Mr. Howard?
16, got an open shoplifting out of Americas. Given false name, on probation for violent crimes out of Fulton, 23 SC 186670. 2025 failure to appear. 2019 FTA theft conviction 2015, and he got charges out of the Army as well.
Thank you. Ms. Falk?
Yes, Your Honor. This incident happened on Georgia Tech campus on June 30th of 2025. The defendant was actually witnessed by the Georgia Tech Police Department riding his bicycle up to a bike rack at that location at approximately 4:22 a.m. near the NAA dining hall. The defendant then took a bike out of the bike rack and left with his bike and then the second bike that he removed. When officers stopped him, he admitted he had taken the bicycle from that location. When asked, "Where did you get the bicycle from?" he again stated he had taken it from that location and was placed under arrest. The recommendation from the magistrate court on this case was, and he does have a fugitive from justice charge out of Jefferson County, Alabama, that he is currently on hold on. He also has a $780 surety bond on this case from the magistrate court. We're asking that that bond remain as set and have the additional provisions that he stay away from all of Georgia Tech property, no alcohol, drugs, or weapons, and that's all for the state.
Stucker.
Yes, Your Honor. Mr. Hall is 43 years of age. He's lived in the Atlanta area for the past 5 years. He does have family in the area as well. He's completed, he has obtained a degree in TV, radio, and broadcasting. He, as it was mentioned, he did serve in the Army. He served 8 years in the Army. He has 2 children. We have no objections to stay away from Georgia Tech locations, and we are requesting a signature bond on behalf of Mr. Hall. And if not appropriate, we are requesting the lowest bond that the court will allow in this matter.
It will be $1,000 good bond. Stay away from Georgia Tech campus property. No drugs, alcohol, weapons while out on bond.
Your
Good
Honor,
luck.
Can you repeat that?
yeah, I
Yes.
apologize. It broke up just as you were saying the bond amount.
Okay, so $1,000 good bond. Stay away from Georgia Tech. No drugs, alcohol, or weapons. Good luck to you, Mr. Hall.
Next is position 6, Mr. Harris.
Good afternoon, Mr. Harris. I'm Judge Eric Morrow. This is, you have been charged in case 25 CR 003688D with simple battery and battery. Is there a history, Mr. Howard?
And yeah, the 2010 ag assault, terrorist threats, decline to prosecute. Everything else is basically pointless. It's over.
Paul?
I'm sorry, Mr. Howard, I didn't hear that last part about everything else.
I said it's old.
Ah, okay. Thank you, Mr. Howard, for repeating that. All right, so this incident occurred on June 30th of 2025. Officers responded to the U-Haul facility at 300 Peter Street in Atlanta, Georgia. They spoke with Malachi King, who's an employee at that location. He stated he was assisting a customer with parking the U-Haul when an altercation occurred. The driver of the vehicle, who was identified as the defendant, became visibly impatient and aggressive. He continued giving directions to her, and when he opened the passenger door, and when the defendant opened the passenger door, he was struck with it. The defendant then exited the vehicle and punched Mr. King in the nose, causing visible bleeding. The defendant, after the assault, the defendant got back into the vehicle, but his daughter refused to leave the scene. The defendant then exited the vehicle and fled the area on foot. A description was given, which then matched the description of the defendant. A show up was done, and Mr. King did identify him as the person who had attacked him. As you've heard, there was an aggravated assault arrest, which was subsequently, it sounds like, closed as part of his case, his previous cases. I know that there should be, and if your honor will just bear with me for a moment, a bond on this case through the magistrate court, given that it's not family violence. There is a $1,500 surety bond on this case, Your Honor. The state would ask that the bond remain as set. We also would ask that the defendant have no further contact with Malachi King, stay away from the U-Haul at 300 Peter Street in Atlanta, no alcohol, drugs, or weapons, and 3-day anger management. We would like to anger awareness. We would like to sound for Mr. Malachi King at this time. That's all for the state.
If Mr. King is on the line and wishes to address the court, now is your opportunity. Doesn't appear so. Ms. Tucker?
Yes, Your Honor. Mr. Harris is a 66-year-old Atlanta native. He's maintained the same residential address for 48 years. He's completed some college. He's currently not employed due to being disabled and receiving Social Security. He does have 2 children as well as some grandchildren that he helps look after. We have no objections to no contact with Mr. King, as well as staying away from the incident location. However, we are requesting a signature bond on behalf of Mr. Harris. His last arrest was in 2012, over 13 years ago, for a driving infraction. He doesn't have any failure to appears. He's maintained the same residence for 48 years. He's not a flight risk. There is not a likelihood that he's going to reoffend or pick up the same charge, considering he's went so many years without any additional cycles on his history. So we are requesting a signature bond on his behalf.
$2,000 signature bond through pretrial level 1. For the simple battery, $1,000 signature bond through pretrial level 1 makes for a total of a $3,000 signature bond through pretrial level 1. 1-day anger awareness, no further contact with Mr. King, stay away from the U-Haul on Peter Street, no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Harris.
Next is position 11, Mr. Lanier.
I have Mr. Lanier as position 10 on my calendar. Good afternoon, Mr. Lanier. You have been charged in case 25 CR 003692B with simple assault family violence. Is there a history, Mr. Howard?
6 on probation for ag assault. 2022 cruelty to animals, better against female who's pregnant conviction. 08 affray arrest. That's it.
Ms. Falk?
Yes, Your Honor. This incident happened on June 30th at 199 Peyton Road in Atlanta, Georgia. The defendant was arguing with the victim at that location, Mr. Patrick Jarrells. They were arguing over, I believe, a rent issue. And at that point, during the argument, the defendant got a sheathed sword and began following Mr. Jarrells around the house. While this ongoing verbal dispute was happening, Mr. Jarrell said that this is not the first time that this has happened, where the defendant has grabbed an object after verbal disputes and had previously threatened to beat up Mr. Jarrells over the issue. So the issue was that the defendant was ordered to pay Mr. Jarrells the amount of $600 or face an eviction based on a decision from the Fulton County Magistrate Court. The officers were also shown a text message by Mr. Jarrells describing previous arguments about the payment between the two, as well as video evidence via the doorbell camera of Mr. Lanier following him outside with the sword that was in a sheath in his hand. We are asking for a $2,500 surety bond, which is the preset bond from Magistrate Court. No further contact with Patrick Jarrells. Stay away from 199 Peyton Place Southwest in Atlanta with a one-time law enforcement escort, no alcohol, drugs, or weapons, particularly no firearms, and we would like to ask for anger awareness as well. We had an opportunity to speak with Mr. Jarrells, and he stated that the defendant was living with him but not paying rent. Through mediation, it was agreed that he would pay $600 by June 30th or leave. They then got into an argument. The defendant began following him around. He described it as a knife in his hand, and he stated this is not the first time the defendant has pulled something out on him during an argument. He pulled out a pan and threatened him in the past, but this is the first time police have been called. He stated he's currently filing for a TPO and he wants no contact with the defendant, wants him to stay away from the residence, and the defendant will need a one-time law enforcement escort to retrieve his belongings. Based upon the fact that the defendant is still on his 10-serve-1 sentence for aggravated assault, 2 counts, cruelty to animals, and battery against a pregnant female from August 24th of 2022, we believe that $2,500 surety bond is fair given all of the circumstances between the two parties and his prior violent history. We would like to sound for Mr. Patrick Jarrells at this time, and that's all for the state.
Mr. Jarrells is on the line and wishes to address the court. Now is your opportunity. Does not appear so. Ms. Armstrong?
Your Honor, thank you. Mr. Lanier has a different address where he can stay upon his release from the Fulton County Jail that's been updated with the court. His phone number has also been updated with the court. We would ask for a surety bond no more than $1,000. I do want to note that Mr. Lanier, he works. He also has a 3-year-old son that lives with his son's grandmother, and he hopes to be out for his birthday in August. Nothing further.
Be $1,000 good bond. No further contact with Mr. Jarrells. Stay away from the Peyton Road address. A one-time police escort to retrieve any belongings. No drugs, alcohol, weapons while out on bond. Good luck, Mr. Lanier.
Next is position 11, Mr. Palmer.
Good afternoon, Mr. Palmer. You have been charged in case 25 CR 003695B with simple battery family violence. Is there a history, Mr. Howard?
I did not see Palmer on my pull sheet. Hold on.
It's the first arrest.
Yeah, it is. I'm looking at it now. Out of Palmetto. That's all.
Thank you. Ms. Falk?
Yes, Your Honor. This incident occurred on June 30th of 2025 between the defendant and his wife, who is, sorry, Your Honor. Who is Miss Riggins. She stated that they were Brianna Riggins. She stated that her husband had pushed her and hit her in the left ear. The officers didn't observe any injury to her ear, and she stated they were arguing over the use of her car. The defendant's license is suspended. She did not want him to drive her car, and at that time, the defendant struck her, and she stated she did push the defendant back in self-defense. This all occurred in front of their 3-year-old child. However, because simple battery family violence is not an offense for which we can add cruelty to children in the 3rd degree, we did have to NOD that charge. The state's recommendation, as this is his first arrest, is SOB through pretrial services. No further contact with Brianna Riggins, given that this occurred yesterday, June 30th. Stay away from 209 Harper Street, Apartment B in Palmetto, Georgia. 1-day anger awareness, no alcohol, drugs, or weapons, and specifically no firearms. We would at this time like to sound for Miss Brianna Riggins.
Address the court. Now is your opportunity to do so. I will need for you to activate your camera for me, unmute yourself, and I'll swear you in. Doesn't appear that Ms. Riggins would like to address the court this afternoon. Ms. Armstrong?
Your Honor, we have the defense has no objection to the proposed bond, with the exception of no further violent contact. It's my understanding that they are legally married, so we just ask that they be able to have no further, that they have no further violent contact. If I misspoke, I apologize, but that's all from the defense.
Did your office speak with Ms. Riggins, Ms. Falk?
Your Honor, we did reach out to Ms. Riggins. We have not spoken with Ms. Riggins, so that is why the state recommended no further contact. Unless the defense has something contrary to that, the state would ask for no further contact.
Okay, Ms. Riggins, if you choose to address the court today, I'm happy to have you. If you choose not to address the court, since no one's heard from you, I'm going to order no further contact at this time. But it's your choice to whether or not you wish to address the court. It doesn't appear that she wishes to address the court. It will be a $2,000 signature bond through pretrial level 1-day anger awareness. No further contact with Ms. Riggins at this time. Stay away from her residential address. If necessary, he can have a one-time police escort to retrieve any belongings. Third-party transfer of any minor children for visitation. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Palmer.
Next is position 12, Mr. Williams.
Good afternoon, Mr. Williams. You have been charged in case 25 CR 003693G with simple assault and disorderly conduct. Their history, Mr. Howard?
2017 theft, probation, 15 felony obstruction, first offender, 14 trespass, window tint, carrying weapon within the school safety zone, marijuana, alcohol, first offender. That's it.
Thank you. Ms. Falk?
Yes, Your Honor. This occurred on June 1st, 2025 at 1360 Seaboard Industrial Boulevard Northwest. That's the Dash Mart. They spoke with Mr. Carlton Thomas, who stated he had been in a verbal dispute with his coworker, the defendant. He told the officer that he and the defendant had prior tension before due to the defendant not doing his part at work. The verbal argument ensued, and the defendant spit in Mr. Thomas's face 2 or 3 times. Mr. Thomas also stated that during the argument, the defendant brandished a handgun in his waistband and started to utter a verbal threat such as, "I've got something for you, and your kids are going to grow up without a dad." Mr. Thomas stated the handgun was never removed from Mr. Williams' waistband and never pointed at him during the argument. There were video cameras, but the officer was unable to see the incident. The officers then spoke with DoorDash, the employer. It said Dash Mart, but it's actually DoorDash. And they did state that upon review, they were able to get the video file from DoorDash. They see the defendant being approached by Mr. Thomas. A verbal altercation ensues, at which point the defendant throws his phone and another object at Mr. Thomas. The two individuals can be then be seen attempting to restrain the defendant, and Mr. Thomas is observed walking away and returning to work while the defendant continues to shout at him. It then continues into the parking lot, and the officers were able to observe the defendant spitting at the victim, Mr. Thomas, on 3 separate occasions. So the state's recommendation on this case, given the fact that the defendant does have a bit of a history, including some violence with that obstruction of a law enforcement officer, is going to be a $1,000 surety bond on the simple assault, $1,000 on the disorderly conduct, no further contact with Mr. Thomas, as well as stay away if he is still, well, the state would need to ascertain if he's still working there, but if he is no longer working there, he would need to stay away from 1360 Seaboard Industrial Boulevard Northwest, which is the DoorDash at that location. No alcohol, drugs, or weapons, and 2-day anger awareness. We would at this time like to sound for Mr. Carlton Thomas. That's all for the state.
Mr. Thomas is on the line and wishes to address the court. Now is your opportunity. Doesn't appear so. Ms. Armstrong?
Your Honor, we would ask that the court consider a signature bond for Mr. Williams. If I misheard, I apologize, but it was my understanding that the obstruction was subject to a first offender. And was that correct? I apologize. I just don't want to misstate. But if so, we would just ask the court to not consider that in terms of a conviction, to impose a higher bond. When we, of course, would avail ourselves to the court for Mr. Williams to take whatever classes you deem appropriate, Your Honor. I do want to note that Mr. Williams is currently in school. He's studying to become something I'm not familiar with, so if I misstated, I apologize, but a cloud computing architect. So again, we're just asked Your Honor to consider a signature bond. Thank you. And he does not work at this location anymore, so we welcome a stay away. Thank you.
Okay. For the simple assault, a $2,000 signature bond through pretrial level 1. Disorderly, $1,000 signature bond through pretrial level 1. Makes for a total of a $3,000 signature bond through pretrial level 1. 2 days of anger awareness. No further contact with Mr. Thomas. Stay away from that DoorDash. Relinquish all firearms. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Williams.
And Your Honor, due to the circumstances of this case, the state does object to a signature bond, being the defendant did brandish a weapon in his waistband and make threats toward the victim, which included that they were going to be fatherless.
Thank you, Ms. Falk. So noted. Who do we have next?
Good afternoon, Judge Morrow. This is going to be position number 9, Ms. Elizabeth Joe.
Courtroom 2. Oh, sorry. Elizabeth Joe is one of the individuals that we asked if it could be held till the end and off the YouTube because of the MH issues.
These are
Okay,
the
so-
last 2. The co-defendant is in courtroom 2.
I'm sorry, you said the co-defendant?
From what I'm hearing, does she have a co-defendant? And that's in
No,
courtroom 2?
they're just 2 separate individuals that needed to be addressed last. Rufus Jones, has he been bonded out? Has something occurred with him? Because he's on my calendar.
Reset.
Say it again.
He's going to be a behavior reset.
Okay, so he's reset to 7-2, position 7 and position 8. And so that leaves Miss Goddess and Miss Jew, is that right?
Yes, Your Honor, that would be the only ones remaining on my list.
And I apologize
Okay.
if I'm speaking out of turn. I apologize, but I did submit a waiver for Elizabeth.
Okay, so do you want, well, she's here, so
Just thought I'd
what
let
do
you
you want
know.
me to? So can I proceed, Miss Armstrong?
Of course, I just want to let you know. Of course,
Oh.
Judge.
Okay. Good afternoon, Ms. Jew. You have been charged in case 25 CR 003691J with battery, family violence,